we've already planned. We have someone who can take care of our finances. We have someone who can file a tax return. We have someone who can write checks on my account. I have someone who can make medical decisions for me when I'm incapacitated. I have made my wishes known with regard to life-sustaining treatment and food and hydration if I'm terminally ill or permanently unconscious. I have done all of those good things, and now I don't have to worry about being incapacitated. So this gets us to the point where we have to talk about the next part of the planning process. Okay, so what's going to happen when I'm incapacitated? This is where it gets a little harder. I often have students come to me, and they're always, they've met with a client for the first time, and they come in, they kind of shuffle into my office, and they say, well, Mrs. Jones is incapacitated. Guess we're done. And what do you suppose my response to that is? Any idea? It's always, well, incapacitated to do what? Because my students fall into the trap of thinking that capacity is global. Incapacitated, I got bigger problems. What do you suppose my bigger problem is? Well, my bigger problem is if they're 100% incapacitated, they certainly can't retain me. I mean, they can't retain a lawyer if they're 100% incapacitated. They lack the mental capacity to do any legal act. If that's what you're telling me, I can't talk to them. They can't retain me. Because in order to retain a lawyer, you have to be able to meaningfully participate in the representation. You have to be able to assist the lawyer in determining the goals of the representation. If you cannot do that, you can't retain a lawyer. And so whenever I have a student come in and say, well, they're incapacitated, you know, I say, well, I guess we'll just have to tell them we can't help them. Well, no, I want to give them some advice. No. You told me they were incapacitated. They're incapacitated. They can't retain you to give them advice. They don't even know what advice they want if they're incapacitated. They can't determine the goals of representation. Oh, no. They know what they want. They want advice about how to transfer their property. So, well, then I guess they're not incapacitated. They might be incapacitated to do a will, but it sounds like they have capacity to retain you as a lawyer. Well, I guess that's right. What about a durable power of attorney? Well, they want their son. They think he's trustworthy. They trust him, and they want him in charge of all their finances because they think he'll do a good job. Really? That sounds pretty close to meeting the Alabama standard for executing a durable power of attorney. Well, okay. So maybe they're not incapacitated, period. Right?
How much variance is there across states?
A lot. There's a lot of variance. There's a lot of variance. And it's really, really interesting because what often happens is someone has already executed a durable power of attorney, and then you have a guardianship proceeding filed. And they may very well find, for purposes of guardianship, that they're incapacitated. But they could also find at the same time that they did have capacity to execute a durable power of attorney. They may still find that. And then what do you do? Then the question is this broad enough that this is unnecessary? And there's a really, really pivotal case in Alabama. It's actually out of Bibb County. I'll come up with the name. Give me a minute. In which the court found that a guardianship action was unnecessary because there was a properly executed durable power of attorney that was broad enough to give the authority necessary to handle the affairs of the incapacitated individual. So that's why we do this. That's why we do this planning process. So we have to move on then. You had a question?
Yes. Do you specify the difference between incompetent and incapacitated whenever you do that? Because I worked in a hospital and when it came down to decision making, there was a difference between patients being incompetent and patients being incapacitated.
Right. There's a connotation. In legal terms, most lawyers would not make a distinction, but I will tell you that amongst people anyway, if you're looking at a close definition of it, generally speaking, someone who is incompetent, the presumption is they will never become competent. whereas someone who's incapacitated may very well regain their capacity at a later date. That's how lawyers in this field would make the distinction. I think that's really, really, a fine distinction. So we have to move on then to what happens if we have decided that in fact our client is incapacitated. And now we have to move beyond who gets to make decisions. We've already made all of our planning. We've already completed all of our planning that we need to do to make sure that we've appointed a medical decision maker. We've appointed a financial decision maker. We have a will in place. All right, and so now those folks are in charge. And now they have to deal with these issues. Long-term care placement. How do we preserve their assets? How do we protect their assets from this kind of exploitation? How do we deal with public agencies like Social Security and Medicare? How do we deal with those groups? Well, first of all, let me tell you that it's important for an agent to understand that every one of those groups is going to, one, want a copy of the durable power of attorney. Two, they're going to ask them for a legal appointment of rep form, and everyone's going to have a different one. Social Security is going to be form 1696. Medicaid has their own unnumbered form. Medicare uses the same Social Security form. They're going to require you to do a new one. And you're going to end up signing it, and every time they're going to have to ask you, why is it that the applicant isn't signing the form? And so that agent is going to have to begin to start dealing with these agencies, and I hope the durable power of attorney is broad enough that it allows them to deal with these agencies. So we have two primary issues then that result from incapacity. One is going to be financial management, and the second one is going to be care. Health, residence, I would say personnel, who's going to provide care and in what setting. And with 5 minutes to 7, because I tend to be long-winded, I'm going to move right into how we deal with long-term care issues. Because that is usually the most pressing issue that agents are asking me about. And we have to recognize from the very outset that if we had proper planning and sufficient funds, we would hope that we have long-term care insurance in effect. Now, if we have long-term care insurance in effect, when do you think we ought to be purchasing it? Now? Now meaning how old?
30. Well, about the time you hit the workforce.
Well, I suppose you could. How do we decide whether to buy it? Everybody should. By the way, in this regard, every one of you should be familiar with the brand new Class Act. Are y'all familiar with that? Have you heard of it? It's part of the new health care legislation. You should all know about it. And the Class Act says that for every employer over a certain size, they must offer their employees the option of opting into a long-term care insurance program. And the employer is required to subsidize some portion of the premium. Okay? And the employee has to actually decline the coverage. Okay? So it gives everybody the opportunity to opt into long-term care insurance that they've not had before. So you should know what the Class Act is, at least basically. So how do we decide whether we need it? The first thing is we assess our risk. What's your health history? Are you going to need long-term care? What percentage of people do you think end up in a nursing home at some point? 5%. All right, I got 5%. Anybody else have a guess?
20.
20%? Anybody else have a guess? Well, this is an educated class, I have to say, because my law students all say 50, 60%. You know, and then I ask them, well, what do you think the percentage is once you get over 80? And once you get over 80, they're like 90%. Everybody's going to the nursing home. You know, I mean, these are some morbid people. You know, like, oh, that's really your expectation. That's how you're going to age. I mean, if that's your plan for aging, yes, you will be in that 80% that goes to the nursing home, if that's your plan. But let's make a better plan than that. But even without planning, right now, overall as a percentage, 24% are going to need nursing home care. The amazing thing is that if we look at those statistics over 80, it's still only 45% spending some period of time in a nursing home. So even over 80 is still less than half. So we have to recognize that overall, this is not really a huge percentage. So why does this have such an impact? Why are people so worried about planning for this if in fact we're looking at a relatively low percentage?
Cost.
Yeah, that's exactly right. It's crazy. The cost is crazy. What does it cost right now in Alabama, you think?
It's $267 a day. The last place I worked, that's without therapy.
$267 a day where he worked last. What do the rest of you think? I mean, it's great when someone can come up with a specific number from some place that they worked. That's pretty good. Medicaid says $4,800 a month, which is roughly $150 to $160 a day for skilled nursing facility care. Now, what do you think the average stay is in a nursing home? Any idea? 3 months? Average stay in a nursing home once you enter?
I would guess years.
Years. Okay.
18 months.
18 months. Well, it's 2.4 years, which means that right now, at $4,800 a month, you're looking at roughly, let's see, that would be 48,000 plus 9,600, 57,600 times 2 would be 115, plus 4, well, let's see, 115, plus another 3 months. So you're looking at about $140,000 to $150,000 for an average stay. Now, what do you think makes this risk go through the roof?
If you have medical complications.
Maybe. You see, this is the interesting thing. When we look at long-term care and we're deciding whether to buy long-term care insurance, we look at the risk, we look at the cost, and when we look at the risk, we're really looking primarily at this, which is, are you likely to need it and for how long? Now, if you were a 65-year-old man and you had a history of hypertension, high cholesterol, high blood pressure, and you went to Liberty Mutual and you asked for long-term care insurance, are they going to insure you? No. Why not?
You're too high a risk.
You're a huge risk, right? Here's the thing. They love that guy. They love that guy. Because when you're dealing with long-term care insurance, the whole world turns upside down. If that guy, 65 years old, high cholesterol, high blood pressure, history of heart disease, goes and applies for health insurance, you're exactly right. Nobody's going to insure that guy. Nobody. But long-term care, they love him. They wish all their clients were like that, because you know what? When that guy goes, he goes. He's gone. He is not going to linger. When he reaches the point where he's incapacitated and he needs skilled nursing facility care and he's going to go in the facility, he's not going to last. With those kinds of medical complications, he's going to go down fast. So who's the worst risk? Who's the person they really don't want to have?